Especially after a long-term marriage, 10 years, 15 years, 30 years, you trust that person. They've been your best friend all these years. This is not a process that you want to handle on your own just for the sake of being amicable about everything. To file for divorce or to file a custody action in Nevada, you need to be a resident of Clark County for the previous 6 weeks prior to the filing of your complaint. For the court to have jurisdiction over your children, the children need to be here for 6 months. Since 2008, a 3-day, 4-day split can now be a joint custodial situation. The law doesn't favor men or women. I have a diverse clientele, whether you're the mother or the father, the grandparents, the domestic partner, the husband, the wife. I don't favor one side or the other. I favor my client. I am going to try and get you the best possible outcome to your case as possible. Just because you visit a divorce attorney doesn't mean we're going out and we're filing something the next day. That's just you gaining knowledge about the law and the process and being able to make the best decisions for yourself and your family. Have all your financial documentation ready. Because financial documents, if you're preparing to separate, those are something that the separating spouse may take with them when they're moving out of the house. You should never come to a forced settlement agreement. You should only settle if it's something that is fair under the law and that you can be happy and that you can live with. I personally like to do roundtable settlement conferences with my client and with the opposing side. But sometimes you have an opposing party who's not willing to settle the matter, they're obstinate, and you do need to fully litigate, and I'm prepared to do that. We're going to prep your witnesses. We're going to go over practice questions. We're going to go over questions that the opposing side may be asking you. There is no disadvantaged person. You're going to meet that other person on equal footing in court. I did an externship for a judge while I was in law school. I also have 2 one-year clerkships with 2 of our family court judges. Because of my experiences at family court, I know what the judges are looking for. I know what's going to resonate with the family court judges. A de facto custody schedule is a custodial schedule that has been in place between you and your partner for any period of time. That could be 3 months, that could be 2 years, 5 years. Maybe there's been a breadwinner that has been seeing their children only on the weekends, only on Saturdays and Sundays. It would be hard for that person to come into court and tell the judge that they want a 50-50 split with their kids when they've been exercising a 2-day-a-week visitation schedule for the last year. If you're unhappy with it, that's why you should get into court and change that situation rather than wait. If you're in an abusive situation, don't wait to contact your attorney. Call the police right away. Get out of the house. Go to a safe house. Make sure that you're safe. You can download the temporary protective order forms online, and they are reviewed 24 hours around the clock. So if something happens on a Friday night, you shouldn't wait till Monday morning to do something. Do something right away so you are protecting yourself. And if you do stay in that situation, it appears to the court later on down the road when you are trying to argue domestic violence and abuse that maybe it didn't really occur because there are no police reports, there are no medical reports. You stayed in a house that you are now telling the court is unsafe for you and your children.